Copyright, Digital Music and the Changing Reality of Karaoke Piracy. Written by Cristina Palmeirim Borges, 25th of August 2026. Introduction. I thought I would put together a number of facts, observations, and opinions concerning copyright and music as they exist today, particularly when compared with the way music ownership and distribution operated several years ago. The transition from physical music to digital music has fundamentally changed the relationship between consumers, copyright owners, record companies, music producers, karaoke producers, streaming platforms, and content creators. One of the most important differences is the distinction between physical ownership and digital access. That distinction is particularly important when considering karaoke piracy. Number one, the difference between physical and digital music. Years ago, a person could purchase an LP or CD and subsequently sell that physical item secondhand. That LP or CD could potentially be purchased legally by another person and then by another person after that. The fundamental difference was simple. The physical object changed hands. If I purchased an LP and subsequently sold that LP, I no longer physically possessed the particular LP that I had purchased. The same principle applied to a CD. The physical copy had been transferred from one person to another. Digital music is fundamentally different. A digital file can be copied. If I purchase a digital file and then transfer a copy of that file to somebody else, I can potentially still retain my own copy. The person receiving it now has a copy while I still have mine. That is one of the fundamental reasons why the legal treatment of digital goods cannot simply be assumed to be identical to the resale of a physical CD or LP. The digital copy can continue to exist after the supposed sale. Consequently, the concept of transferring ownership of digital material is considerably more complicated than transferring ownership of a physical object. Number two, the digital rip from a physical CD. There is another important distinction. A person who legitimately owned a physical CD could, depending upon the law applicable at the time and the circumstances, make a digital copy for permitted purposes. However, that did not automatically transform the digital copy into an independently transferable commercial product. The legal position concerning a digital copy could remain connected to the person's rights in the original physical recording and the applicable copyright law. If the person subsequently sold the physical CD, that did not necessarily mean that the person automatically acquired the right continue distributing copies of the music to other people. This is precisely where many people fail to understand the difference between copying for permitted personal purposes and commercial redistribution. The fact that somebody possesses a digital file does not by itself establish that the person possesses the legal right to redistribute that file. Number three, karaoke piracy in the digital age. This distinction is particularly important in the karaoke industry. A large proportion of modern karaoke material is distributed digitally. Unlike an old physical karaoke disc, a digital karaoke track can be copied repeatedly without the original copy disappearing. One person can have it, another person can have it, a third person can have it, the original purchaser can still have it, and copies can potentially be distributed to hundreds or thousands of other people. That is precisely why digital piracy is so destructive. The person making the unauthorized copy does not have to surrender the original. The original creator therefore loses control over the distribution of the work while the pirate retains the copy. Number four, karaoke companies can have records of their customers. There is another factor that many karaoke pirates appear not to understand. Karaoke companies selling their productions digitally can maintain records of their legitimate customers and transactions. An online purchasing system can potentially record who purchased a track, what was purchased, when it was purchased, the customer's account, the customer's transaction history, payment information, and other information associated with the transaction. Consequently, if a karaoke producer discovers that its commercially distributed track is being used by somebody whose purchase records do not correspond with possession of that material, that can create a very obvious question concerning the provenance of the copy. It does not automatically prove infringement by itself because legitimate licenses, promotional copies, business arrangements, transfers, and other lawful explanations can exist. However, it provides a potentially valuable starting point for investigation. Number five, the stupidity of publicly advertising huge karaoke collections. This becomes particularly interesting in South Africa. Karaoke operators regularly advertise their services online. Their advertisements, Facebook pages, websites, posters, videos, and other promotional material can potentially be seen anywhere in the world. That includes by the karaoke companies that created the material. If somebody publicly advertises, we have hundreds of thousands of karaoke tracks, the person has potentially created an enormous piece of evidence concerning the scale of the collection being used. The internet does not recognize the geographical boundary of South Africa. A karaoke producer in the United Kingdom, United States, Europe, Australia, or elsewhere can potentially see the advertisement. And when somebody publicly boasts about possessing an enormous catalog, the obvious question becomes, where did all those tracks come from? If the person cannot demonstrate legitimate acquisition of the material, the advertisement may become considerably more problematic. The person may effectively have advertised his own potential evidence. Number six, why have karaoke companies not launched mass litigation against South African karaoke hosts? This is where the situation becomes considerably more complicated. There are several reasons why karaoke companies may not have pursued every suspected pirate through massive litigation. One of the important issues is the complicated structure of music copyright and licensing. A karaoke company is not necessarily the owner of the underlying copyright in the original song. The copyright in the musical composition may belong to the songwriter, composer, publisher, or another rights holder. The copyright in an original sound recording may belong to a record company, label, artist, or other rights holder. A karaoke company may instead have obtained permission to use those works in creating its own karaoke production. That distinction is crucial. Number seven, SAMRO and karaoke rights. In South Africa, organizations such as SAMRO operate within the music rights and royalty environment. However, the existence of a license or payment to a collecting society doesn't automatically mean that every karaoke producer whose production is being used has received payment. The underlying rights can be divided among different rights holders. A karaoke producer may have obtained permissions directly from record companies, labels, publishers, artists, or other rights holders. The karaoke producer may therefore have rights arising from its own production and licensing arrangements that are separate from the rights administered by a collecting society. It is therefore important not to assume that paying one organization automatically settles every possible right associated with every karaoke production. The specific license must be examined. The specific rights must be examined. The specific repertoire must be examined, and the actual agreements must be examined. Number eight, why karaoke companies have their own licensing problems. The karaoke companies themselves face an extremely complicated licensing environment. A karaoke production is not simply a song. It can involve the underlying musical composition, lyrics, the original sound recording, a newly produced backing track, mechanical rights, reproduction rights, synchronization, artwork, graphics, video, branding, trademarks, lyric timing, and other intellectual property elements. The karaoke producer, therefore, has to obtain the permissions necessary to create and distribute its production. This becomes particularly difficult when the product is distributed internationally. Number nine, the move from physical discs to digital distribution. When karaoke companies primarily sold physical discs, their geographical distribution was comparatively easier to manage. Digital distribution changed everything. A digital karaoke track can be purchased from one country and downloaded by somebody in another country almost instantly. A producer that sells internationally can therefore find itself dealing with licensing issues across numerous jurisdictions. The international licensing burden can potentially involve major territories, such as the United States, United Kingdom, Canada, Australia, European countries, South Africa, and other major music markets. Depending upon the particular rights involved, licensing can become extremely complicated and expensive. For a small karaoke producer, attempting to establish and maintain individual licensing arrangements across numerous territories can become financially unrealistic. Number 10, YouTube provided an alternative model. This is one reason why some karaoke producers move towards YouTube. Instead of attempting to sell every karaoke production individually throughout the world, a producer can place its creations on YouTube and use the platform's copyright management and monetization infrastructure. Where the necessary rights and permissions exist, the producer can operate within YouTube's licensing and Content ID environment. Instead of receiving a fixed amount from every individual purchaser, the producer can potentially receive advertising revenue generated from legitimate viewing. The income from an individual view may be extremely small. However, thousands or hundreds of thousands of legitimate views can collectively produce meaningful revenue. The business model therefore changes from sell one track, receive a fixed payment to create and license the production, publish it, receive legitimate views, generate advertising revenue. For smaller producers, this can be a considerably more practical international model. Number 11. But viewing a YouTube video does not mean owning it. This is one of the most important points. The fact that a video is freely accessible on YouTube does not mean that the viewer owns the video. It does not mean that the viewer has purchased a transferable copy. It does not mean that the viewer has received permission to download it. It does not mean that the viewer can put it onto a karaoke hard drive. It does not mean that the viewer can distribute it to other karaoke operators. And it does not mean that the viewer can commercially exploit it. YouTube's terms of service distinguish between access to content through the service and ownership or unrestricted rights in that content. YouTube's terms also restrict various forms of downloading, reproduction, distribution, public use, and commercial exploitation, except where expressly authorized by YouTube, the applicable rights holder, or applicable law. The official YouTube terms should therefore always be consulted rather than relying upon assumptions concerning what is permitted. Number 12. If it is on YouTube, I can use it, is wrong. This is one of the most dangerous misconceptions. Putting something on YouTube does not place it into the public domain. A YouTube upload remains subject to the rights applicable to the material. A creator may have spent hundreds of hours creating content. A music producer may have spent thousands of pounds or dollars producing material. A karaoke producer may have spent several hours producing one karaoke video. None of that work becomes free merely because the finished product is visible on YouTube. Accessible does not mean ownerless. Viewable does not mean downloadable. Downloadable does not mean legally distributable. And free to watch does not mean free to commercially exploit. Number 13. The karaoke producer does not necessarily own the song. This is where copyright becomes complicated. A karaoke producer may not own the copyright in the underlying musical composition. The producer may not own the original recording. The producer may instead have received permission from the relevant rights holders to use the music and lyrics. The producer can therefore be a licensee rather than the underlying copyright owner. This distinction has historically created difficulties when karaoke companies attempted to enforce their rights. If a karaoke company does not own the underlying copyright, it cannot simply claim ownership of the underlying musical composition merely because it produced a karaoke version. However, that does not mean that the karaoke producer owns nothing. Number 14. What the karaoke producer does own. The karaoke producer may own rights in the material that it independently created, depending upon the applicable law and the circumstances. That can include original graphics, artwork, logos, branding, video presentation, visual design, original audio production, backing track production, arrangement, lyric synchronization, timing, editing, production techniques, original written material, and other original creative elements. Therefore, the fact that the producer does not own the underlying song does not automatically give everybody else permission to copy the entire karaoke production. There are potentially multiple layers of intellectual property. The underlying song is one layer, the original recording is another. The karaoke production can contain additional creative layers. The logo and branding can create further rights. The artwork can create further rights. The precise legal position depends upon what was created, who created it, what rights were obtained, and what licenses were granted. Number 15. Why some earlier karaoke cases were difficult. Historically, Some karaoke companies discovered that their enforcement cases were difficult because they attempted to rely upon rights they did not actually own. If the underlying music and lyrics belonged to somebody else, a karaoke producer could not simply pretend that it owned those underlying rights. The industry, therefore, had to understand that the correct legal claim had to be based upon rights actually held by the producer. In some circumstances, that could include its own original production, graphics, artwork, branding, synchronization, and other intellectual property. The lesson should have been obvious. Know exactly what you own, know exactly what you have licensed, know exactly what rights have been granted to you, and enforce the rights that you actually possess. Number 16, logos, artwork, and branding are not irrelevant. One particularly overlooked issue is the unauthorized use of a karaoke producer's branding. Suppose a producer creates a karaoke video containing its own logo, its own artwork, its own graphics, its own contact information, its own branding, and its own lyric synchronization. Someone downloads that video and uses it at a commercial karaoke event. The person has not merely obtained access to a song, they have potentially taken an entire independently produced commercial product. The underlying musical rights and the producer's own intellectual property rights are separate questions. A producer therefore needs to examine every component of the copied production rather than assuming that the only relevant issue is the underlying song. Number 17, express warnings make the position even clearer. In my own productions, I make it expressly clear that the karaoke videos are not to be downloaded and are strictly intended for private home use through the YouTube channel. That warning is placed within the videos precisely because people may not understand the applicable YouTube rules. It removes much of the ambiguity concerning the intended use of the material. If somebody then downloads the production, removes it from YouTube, and uses it commercially at a karaoke event, that person cannot reasonably claim that the producer never communicated its position. The warning is there, the producer's intention is there, the platform's terms are there, and the subsequent commercial use may potentially be established through evidence. Number 18, commercial use at a karaoke venue. Consider the following situation. A person watches my karaoke production on YouTube. That is one situation. The same person then downloads it. He stores it on a hard drive. He places it into his karaoke software. He takes it to a public venue. He uses it for a karaoke event. The venue pays him, or customers pay the venue. He advertises the event. He continues using the material at other venues. That is no longer simply somebody watching a YouTube video at home. The material has been removed from the platform and incorporated into a commercial activity. The legal consequences depend upon the particular rights, licenses, agreements, and applicable law, but the argument that I only got it from YouTube does not by itself provide a legal defense. Number 19, the popia issue. There can also be other legal considerations beyond copyright. One of these is South Africa's Protection of Personal Information Act, commonly referred to as POPIA. POPIA regulates the processing of personal information and establishes conditions concerning lawful and reasonable processing. Depending upon the circumstances, personal information can include information such as names, contact details, email addresses, telephone numbers, location information, online identifiers, and other information capable of identifying a person. However, POPIA should not be treated as though it simply replaces copyright law. It is a separate legal framework. Whether POPIA is relevant to a particular dispute depends upon the actual facts and the way personal information has been processed. Therefore, where a karaoke producer believes that its personal information, contact details, or other protected information has been unlawfully reproduced, processed, or used, the appropriate legal provisions should be examined by a qualified South African attorney. The important point is that copyright may not necessarily be the only legal issue involved in the unauthorized use of a complete karaoke production.